Do you need a will if you already have a trust in Georgia? So you've already set up a revocable trust, all of your assets are set to avoid the probate process, but here's a mistake that a lot of people make. They'll set up that revocable trust and forget to set up a will to go along with it. The problem here is going to be that you have the trust for years or potentially decades. And when you have a trust for that long, it's very likely that you're going to forget to put assets inside of there. When you buy and sell assets, you forget to name the trust as a designated beneficiary on any of your financial accounts. And then when you pass away with assets in your personal name because you have forgotten to put them inside the revocable trust, those assets will have to go through the probate process and be distributed per the intestate laws of Georgia. And then the courts will decide how your assets are being distributed, not the trust document. And so in this video, we're going to cover why a trust does not replace a will, what happens if you do not set up a will, the special kind of will that you need to set up when you have a revocable trust. So let's get into it. The first thing is going to be why a revocable trust does not replace your will in Georgia. A revocable trust only accounts for the assets that are actually inside of that trust, while a will is going to account for all the assets that are in your personal name. And you might be thinking, you know what, I'm setting up a trust, I'm putting the assets inside the trust, I'm not going to have any assets in my personal name when I pass away. The problem is going to be that people will always at some point forget to put an asset inside of the trust, whether it's because of they just forgot, they didn't have time, or they were not organized enough. This could be a bank account that you forgot to transfer into the trust, a property you forgot to transfer inside the trust, it happens, a car that you kept titled in your personal name, an LLC that you forgot to transfer the membership interest into the trust. And if there's no will and those assets are in your personal name when you pass away, the courts will decide how your assets should be split up, and it's going to be per the intestate laws. And so while the trust will help your assets avoid the probate process, it only accounts for the assets that are actually inside of the trust. So what happens if you pass away with a trust, assets in your personal name, and you do not have a will? The assets in your personal name will have to go through the probate process. A judge will appoint someone to manage the assets inside of your estate and distribute those assets out per the intestate laws. Your family is going to have to spend $5,000 to $15,000 to open up a probate process and have a probate attorney help them through that process. This can become quite expensive and quite a headache for your family, and it leaves everything up to the courts on who should be managing the assets and how those assets get distributed out to your family. So what type of will do you need when you already have a revocable trust set up? This will is going to be called a pour-over will, so any assets you forget to put inside of your trust or you don't have time to will have to go through the probate process, but the pour-over will capture those assets and dump them into the revocable trust on the back end of probate once it's done. That way those assets will get distributed and managed per the guidelines inside of that trust document. So how do you set up a pour-over will? You're going to name an executor of your pour-over will. You're going to put pour-over will language inside of that will document that will dump all the assets into your revocable trust. You will reference the full legal name and the date that your trust was created. As an example, the John Smith Living Trust dated January 1st, 2024. And you don't have to, but it's always a good idea to put a self-proving affidavit on that will document. That way it's proved. They don't have to call witnesses or anything like that when the probate process is happening to validate that will. Also, please note that this does not avoid the probate process for assets that you forget to put inside of your trust. It's going to make those assets go through the probate process, which they'll have to anyways, but it puts them into the revocable trust on the back end of probate instead of being distributed per the intestate laws. That way those assets will get managed and distributed per the instructions inside of that trust document. So let's talk about how to make all of your assets avoid the probate process. When we set up a revocable trust, we're going to put all the assets into the trust. So when we have real estate, we're going to retitle that property into the name of the trust. If we have LLCs with rental properties or a business, we're going to transfer the LLC membership interest into that revocable trust. If we have financial accounts like checking, savings, investment, retirement, or life insurance policies that we want to pay into that revocable trust, we would name the revocable trust as a designated beneficiary on all of those accounts. And then we want to make sure that we are reviewing this at least once a year. That way, if we're buying or selling assets, or we're setting up new investment accounts, or getting into new investment types, whatever that might be, we are making sure that those assets are being accounted for inside of that trust document so that all of those assets will avoid the probate process when we pass away and go directly down to our family. If you need a trust so that your assets will avoid the probate process, our trust packages will come with a pour-over will included. It's not sold separately. Everything's included inside that package. Click link in the bio, fill out the form, and schedule a time to talk to some of our team.